Public Protector Advocate Busisiwe Mkhwebane filing an urgent application in the Western Cape High Court, asking that court for an order enforcing the immediate effect. It's a Friday judgment setting aside President Cyril Ramaphosa's decision to suspend her in June. We're going to speak to Advocate Hoffman as soon as we get him on the line. And of course, he's the Accountability Now Director. Advocate Hoffman, we really do appreciate you staying with us. Apologies for that, as we're crossing to quite a number of breaking stories around the world. You were saying that much focus, of course, should be put on what the Democratic Alliance is doing. And of course, this legal conundrum seems to be far from over.
Wrestling going on between the Public Protector and the Democratic Alliance. The Public Protector has managed to persuade 3 judges in the Cape High Court to say that the President has acted unconstitutionally in suspending her. Now, the power of suspension is one that is given in terms of the Constitution in order to exercise control over any Chapter 9 institution that is not being run along constitutional lines. You will know, and your viewers will know, that the Public Protector is a Chapter 9 institution, and that the work of the Public Protector is most important in order to see to it that there is not maladministration or malfeasance in the affairs of state and in the public administration. That is an important job that relates to bedding down constitutional democracy in South Africa. The Public Protector is taking the attitude that she wants to cling to the judgment of the High Court, and she is seeking to put a meaning on parts of the Constitution which is very difficult to understand, and which it is unlikely that the Constitutional Court will countenance them. So it's probable that the appeal of the DA will be given preference on the roll for hearing in the Constitutional Court, and that in the meantime, the Public Protector will remain suspended. The fact that she's suspended does not mean that she is not entitled to her emoluments. She is on a precautionary suspension, and she really does have her hands full with the parliamentary hearing into her fitness for office. So the way ahead is really what the President was talking about in the clip that we watched just before we looked at the Queen. And what the President has said is correct. The question of whether or not his conduct was unconstitutional is something that has to be confirmed by the Constitutional Court, and it boils down to whether there was a risk of a conflict of interest. The court in Cape Town went further and said that there was a conflict of interest, which is really not the test. The test is whether there was a risk of a conflict of interest, which is actually a higher test than the usual recusal test. And that issue is going to be determined in the Constitutional Court. I doubt that the Public Protector can show any grounds for urgency.
Does this mean that Advocate Mkhwebane still needs to then appear before Parliament's Section 194 committee while all of these other legalities unfold?
Yes, the litigation that was terminated in the High Court last Friday also involved an attack on the Speaker's decision to proceed with the disciplinary inquiry, if you want to call it that, the Section 194 inquiry, actually. And the Public Protector lost on that front. So whether she is reinstated or not, she is going to be spending much of her time in the hearing in Parliament. And of course, we all know that her term of office ends in October next year.
So, what leg, if at all, does Advocate Busisiwe Mkhwebane have in terms of this application in the Western Cape High Court? You've already spoken about the aspect of... Go ahead, Advocate.
Yeah, I'm with you. I think that she's going to struggle because if it is correct that the president had a risk of a conflict of interest when he decided to suspend her because of the bad blood between them and the parlor questions and all of those things, then if the Constitutional Court decides that that is the case, then the next step in the matter is to look to the Constitution as to what happens when a president has a risk of a conflict of interest that disables him from acting in any particular decision-making capacity. And the Constitution is very clear about that. When the president is unable to act, the deputy president or the speaker can act in his place. And that is what will happen here. If the public protector wins on all counts, the deputy president will apply his mind to what is going on. He will be able to look at what has happened in the parliamentary inquiry as well. And he will then make his own decision as to whether or not she should be suspended. And we'll be back where we are the day before yesterday.
And I guess what will form part of that argument would be the public protector advancing that it was after she had sent those questions to the president that she'd been suspended.
Yes, the timing is, as you suggest, but whether the factual background is sufficient to suggest that there is a risk of a conflict of interest between the private interests of the president and his public responsibility to suspend is a question that will eventually be answered by the Constitutional Court. I cannot see the High Court accepting that the matter is anything other than one which should be confirmed by the Constitutional Court. The High Court does not have the power to rule on the conduct of the president, and to the extent that the High Court has sought to bring in the common law test for recusal, that really is legally irrelevant, because the correct test under the Constitution is whether there is a risk of a conflict of interest. And there is a dispute as to whether that is actually a sufficient basis for a conflict. And that dispute will be determined by the Constitutional Court.
Advocate Hoffman, thank you very much indeed. We really appreciate the time.